Well, friends, yet again, another one of Donald Trump's lead lawyers quits. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, remember this guy? Joey, forget about it, Tacopina. Okay, forget about it is not really his middle name, but you know. So attorney Joey Tacopina represented Donald Trump when Donald Trump lost bigly to Ms Carroll in Ms Carroll's first defamation suit brought against Donald Trump, and the jury ordered Donald Trump to pay Ms Carroll $5 million for the damages he inflicted on her. And Joey Tacopina is still representing Donald Trump in the appeal of that case. Tacopina is also representing Donald Trump in his criminal prosecution in New York. That's the one where District Attorney Alvin Bragg indicted Donald Trump for his hush money payments to playmates and porn stars, basically to try to gain unfair advantage in the 2016 presidential election. In a very real sense, that was Donald Trump robbing the American voters of the full value of their vote. And Donald Trump has been indicted on dozens of felony charges for falsifying business records in connection with those hush money payments. Joey Tacopina represents Donald Trump in that criminal prosecution as well. And friends, let's not forget, we are on the eve of jury selection in Ms. Carroll's second defamation trial against Donald Trump. Now, technically, Tacopina doesn't represent him in that case, but he does represent him in two of the other cases. And now, Joey Tacopina just quit representing Donald Trump. Let's start with the new reporting. This from the New York Times. Headline, Key Trump Lawyer Withdraws as Manhattan Criminal Trial Nears. And that article begins, Joseph Tacopina, the trial lawyer on Donald Trump's legal team with the most successes defending high-profile clients, will no longer represent the former president in his criminal trial in Manhattan, according to a notice sent to the court on Monday. Mr. Tacopina also withdrew on Monday from another case in which he was still legally representing Mr. Trump, an appeal of the verdict in a lawsuit brought by writer Ms Carroll. Mr. Trump was found liable last year and ordered to pay Ms. Carroll $5 million. It was not clear why Mr. Tacopina decided to withdraw, and he declined to comment. His departure from the two cases comes as Mr. Trump enters a year of legal uncertainty. He faces 4 criminal indictments and trials with dates that are up in the air. The trial in Manhattan, in which he is accused of falsifying business records to hide hush money payments to a porn star during the 2016 election, could begin as early as March. Its timing may depend on whether the federal trial accusing Mr. Trump of illegally trying to subvert the 2020 election is delayed. That trial is also scheduled for March. The withdrawals came a day before jury selection is set to begin in a second trial, stemming from the allegations brought by Ms. Carroll. Mr. Trump recently told the New York Times that he wanted to testify in the new trial and that Mr. Tacopina had advised him against doing so in the first one, the first trial, a decision the former president said he regretted. During his closing arguments in the earlier trial, Mr. Tacopina noted that Mr. Trump did not testify and described it as the right decision. Interesting that Tacopina says, all the decisions I made were the correct decisions in that trial in which my client, Donald Trump, went down in flames. Interesting. The article continues. During closing arguments in the earlier trial, Mr. Tacopina argued that jurors were entitled to their personal views of Mr. Trump, but he suggested the case was aimed at harming his client politically, a widespread view in Mr. Trump's world. Quote, "It's okay, however you feel about him," Mr. Tacopina said. "I said this before, you could hate Donald Trump, it's okay. But there is a time and a secret place to do that. It's called a ballot box during an election. It's not here." It's interesting, friends. It almost sounds like Joey Tacopina is telling the jurors they shouldn't vote for Donald Trump. That is perhaps a rare area of agreement that I have with Joey Tacopina. But let's now turn to two questions. One, why do attorneys quit cases? Why do they want to walk away from their clients? And two, what are the consequences when they do? Right? What's the fallout? What happens next? Let's start with the two most ordinary reasons attorneys try to quit cases. One will come as no surprise to you: money. The client stopped paying his or her legal bills. So the attorneys want to quit. They want to withdraw as counsel, right? They want to be paid for their services. Now, can you imagine Donald Trump not paying his lawyers? Of course you can. There's been lots of reporting about how Donald Trump has stiffed his own lawyers. The second most typical reason lawyers will quit a case is because they have irreconcilable differences with their client, generally involving how the case should be defended or presented. And if the attorney can't, in good conscience, present the case or defend the case the way the client wants, the attorney can move to withdraw. Irreconcilable differences, and the client really needs to get himself or herself another attorney who will fall in line with what the client is demanding by way of a defense or the presentation of a case. So those are the two main reasons attorneys quit: money, irreconcilable differences about how the case should be presented or defended. Now, what happens when an attorney files a motion to withdraw, wants to quit the case? Well, it really depends on whether it's a civil case or a criminal case. In a civil case, attorneys typically have much more leeway to withdraw, to quit, because, in a civil case, nobody is locked up, nobody's detained pending trial, nobody is at risk of going to jail or to prison, and the courts, the judge, will generally grant a motion to withdraw, let an attorney quit the case, and then new counsel will come on to the case. As you can imagine, that can result in a continuance of a trial date. Now, let's turn to a criminal case. In a criminal case, once you undertake to represent somebody as a defendant who is being prosecuted by the state or by the federal government, you may be stuck with that client whether or not that client keeps on paying his or her legal bills. You may be stuck with that client even if you and the client have irreconcilable differences about how the case should be defended. So just because an attorney wants to quit a case, that does not mean the judge has to grant the motion to withdraw. Why? Because the judge has considerable leeway in administering the system of justice in a way that avoids unnecessary delay, that gets the case to trial in a timely manner. So let me tell you, friends, over the years, I was a prosecutor for 30 years. Over the years, I have had defense attorneys move to withdraw, try to quit the case for any number of reasons, and the judge ended up denying the request and saying, no, we're going to trial. The trial date has been set. Maybe the trial date is 1 week down the road, and I will not grant your motion to withdraw because that would result in a trial delay. And that is within the judge's discretion. The judge has to hold a mini hearing on it, The judge has to make sure he or she gets the call right, because if they get the call wrong, then the appellate court might reverse any conviction that ultimately came after the judge made an incorrect or unsupportable ruling on a motion to withdraw. But let me tell you, any number of times I kind of smelled that a motion to withdraw may have been made just for the purposes of delay. Judges can usually sniff that out as well. The other thing is, if you have a problem as a lawyer with your client not paying your bills in the context of a criminal case, the judge will tell the attorney flat out, that's your problem. You go ahead and resolve that with your client after this case is over. You have to sue your client after the case is over, so be it. Think about Rudy Giuliani. He's being sued by some of his attorneys for not paying his legal bills. So usually, non-payment of legal fees by a client is not enough to have a judge grant a defense attorney's motion to withdraw, approve a defense attorney's request to quit the case. If it comes to irreconcilable differences, differences in the tactics of how the case should be presented or defended, ordinarily this is what happens. The judge will not automatically just grant the motion to withdraw, let the defense attorney quit the case because he or she says, oh, judge, we have irreconcilable differences. The judge will hold a hearing, and the judge will hold that hearing ex parte. What does that mean? It means the prosecutor is not included in the hearing. The defense attorney and the defendant, the client, will go up to the bench. I will stay at counsel table, and the court will put on the husher, which provides white noise for the courtroom so I can't hear what's going on up the bench. And I have had judges sit up there for hours talking with the client and the defense attorney and trying to hash out whatever these irreconcilable differences are. Because at the end of the day, the defense attorney has a pretty wide berth to defend a case as he or she sees fit. There are only a few decisions that the defendant gets to dictate or gets to veto if the defense attorney gives him advice, like the right to testify or the right to decline to testify. The defense attorney can tell the client all day long, I really think you should, or I really think you shouldn't testify, but it is the defendant's right to make that decision himself. And if the defense attorney says, look, he's going to tank his case, judge, if he testifies, I've told him that, the judge will say, that's not an irreconcilable difference because it's not your decision to make, Mr. or Ms. Defense Attorney. It is the defendant's. What witnesses to call? Not the defendant's decision to make. That's a tactical choice of the defense attorney. So the judge, and I have seen judges do that, will work through all of these alleged irreconcilable differences, and at the end of the day will say, listen, you may have your differences, but I find they do not rise to the level of me being required to grant your motion to withdraw. Your request to quit the case is denied. We're going to trial. That happens all the time, friends. So friends, now let's turn back to the question of why Joey Tacopina is trying to quit the case. Why has he filed a motion to withdraw as Trump's lawyer? Well, we don't know because he was asked and he refused to answer the question. He wouldn't comment on that topic. But let's look at some of the possibilities. He did lose the first big Donald Trump trial, the case E. Jean Carroll brought against him, and he lost to the tune of $5 million that his client has to pay out. Maybe Donald Trump fired him. Maybe it's over money. Maybe Trump is no longer paying his legal fees. Maybe there are significant tactical disagreements and he believes they have irreconcilable differences. Maybe he's just being tired of being yelled at by Donald Trump. We don't know, and Joey Tacopina hasn't offered any comment on the subject. When asked about why Joey Tacopina is quitting, here is what a Donald Trump spokesman said about that. Asked for comment, Stephen Chung, a spokesman for Donald Trump, did not directly address Mr. Tacopina's departure, saying only that Mr. Trump has the most experienced, qualified, disciplined, and overall strongest legal team ever assembled. You know, I'm sure Trump would have added, nobody's ever seen anything like it in the history of the world. So think about it. Donald Trump was asked, why is Tacopina quitting? And the Trump spokesperson said, Mr. Trump's legal teams are the biggest and the strongest and the most handsome known to man, in substance. So Donald Trump isn't saying why Tacopina wants to quit, wants to withdraw as counsel. So hopefully this will not derail or delay the criminal prosecutions that are pending against Donald Trump, because the New York prosecution for his hush money payments, for his felony falsification of business records, that's scheduled to begin in late March, just around the corner. Of course, the only way that one would begin is if Donald Trump's criminal prosecution in Washington, D.C. for trying to overturn the results of the 2020 election actually begins on March 4, as it is scheduled. You know, the music is still playing, and we're waiting for it to stop so we can see in which defendant's chair Donald Trump is forced to sit. New York, D.C., Florida, Georgia. But hopefully this attempted motion to withdraw by Tacopina, in connection, most importantly, with the New York State prosecution scheduled for, I believe, March 25th, hopefully it doesn't impact that case. I believe there are other defense attorneys who are still representing Donald Trump in that case, even if Tacopina was the lead attorney. So in the event that is the first criminal trial to go, if the March prosecution in D.C. ends up being pushed down the road a little bit because the Supreme Court is playing with questions like absolute presidential immunity, president being king, that could hold things up in D.C. a little bit. That would free him up to go to trial in New York in late March. And hopefully, if Tacopina walks off the case, as he is trying to do, he's waiting for the judge to grant his motion to withdraw. Hopefully that does not impact the New York prosecution, currently set for the end of March. Because one way or another, Donald Trump needs to get to trial, needs to be tried fairly, needs to be convicted in accordance with the evidence for the crimes he committed in the many jurisdictions in which he's being prosecuted, not for political reasons, but because with a presidential election coming up in November 2024, I actually think all of the voters, including the Trump supporters, have every right to know whether they're casting their ballot for a convicted felon or they're casting their ballot for a completely innocent man who has gone to trial and been found not guilty by a jury of his peers and has been exonerated, cleared of all wrongdoing. Every voter, left, right, and center, has a right to know, in the event Donald Trump is the Republican nominee, who they are voting for, what they are voting for. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.